make sure that I have my friends' questions. Okay, I think you covered pretty much all of them. No, order to go. Sounds like takeout. Okay, anyway, you know how the judge write order to go. I mean, why? Is there an order to come? Like, what is the significance of the term?
That is the judge's endorsement. The
Oh,
judges say, okay, it just say, it could, okay, it's a colloquial term. Like I said, judges' endorsements are quite often a little bit informal.
yeah.
It says, if the judge was being really formal, the judge would have written in their endorsement, this order this order is to be issued and finalized. But instead, it's like the order to
Oh,
go. The order is to go in accordance with this endorsement. Order to go, that's what it means. It's because the judge will have made their endorsement. It's just, yep, order is to issue in accordance with what I've said in my endorsement.
oh, okay. Like it's like shorthand to express.
Yep. Some judges will do really, really shorthand. What they might do in their endorsement is they will say order to go in accordance with paragraphs 1, 2, 7, 8, 12, 15, and 24 of the notice of motion.
I see. Okay, got it.
That's
I
their
understand now.
endorsement. And then you go back and what those are, you got to go back and read them. But when you do the order, you actually have to type out all those paragraphs in
Okay.
full in
I
the order.
see. Got it. It's also interesting that when you go on Canly and you research case law, and some of the case law is actually it just says endorsement, right? Like so, it says endorsement, and then actually sometimes the judges they go at length to explain their decision. And I guess this is another thing that I just realized that and in an endorsement, the judge can talk about quite a lot about this, even the story sort of the
Yeah.
dispute. But the draft order, the order doesn't have the story, right? The order is an
No, the
order.
order just is directive. The order contains the judge's decision on the issues that are there. Sometimes
Right.
what you'll also see, what a judge will do in their endorsement is they're called reasons for judgment.
Reasons
Like
for yes.
if the judge has done
Yeah.
a trial, that's where the judge will go through and saying, these were the parties, these were the facts, these were the
Yeah.
facts that were not disputed. If this was an allegation by the applicant, this was an allegation by the respondent. I have credibility issues on this point with the respondent because blah, blah, blah. So the reasons for judgment are contained in the endorsement as well. Whereas the order itself is always just, okay, what do the parties have to do? Yes, it doesn't go through the background, it doesn't go through the story, it doesn't go through the reasoning or anything else. The reasoning is in the reasons for judgment, which will be in the endorsement, but the judge will always say in the endorsement, order to go as
Right.
follows. And it will either be just saying quoting the sections
I
from whatever was claimed,
see.
or the judge might actually write out all the final terms of what is to go. So order to go in the following terms, and they will write it all out.
Oh, I
And
see.
then the
Yeah, yeah,
order
yeah.
itself will just have that chunk.
Okay. Now just a couple more questions and then we're done, promise. So just to make sure I understand this. So a 14B motion, it is permissible for the responding party to respond. I mean, like, it's not like you're not allowed to oppose it, right? Because you just
You
said
may argue.
yeah. So, because for some reason at the beginning, I thought that 14B motions are simple, uncomplicated, and usually on consent. But it seems that if you want to oppose it, you can because they allow, the rule says so here, right? Like you can serve and file a response
You
within
have to,
four
yeah.
days. So you could
And
oppose
this
it.
is always why I say, even with the Form 14B motion,
Yeah,
it's always a good idea for the party that's bringing the 14B motion and the
yeah.
person who's responding to it to if they can, if it's available in their region. If they don't have their own lawyer or somebody to ask as a private lawyer, to contact the duty counsel office and ask. Because I've done first appearances as duty counsel where neither party is represented. The applicant has started the proceeding. The first appearance is like 45 days after the application was served on the responding party. The
Yeah.
responding party hasn't filed any materials. But now they're at the first appearance and the clerk says this matter is not ready to proceed because the respondent has not filed any materials. And then the respondent is there on the first appearance and says, look, I need an extension of time to file. It took me a while to find a lawyer. The lawyer's working on it right now. I do want to file. I just need more time. And the applicant says, screw you and the horse you rode in on. I'm mad. This has been going on for months already. You made me
Mhm.
bring you to court. You had your 30 days. I'm not consenting to an order for late filing. And then what'll happen is the matter will get adjourned to another first appearance. If I had had the opportunity to speak to the applicant as the duty counsel, my advice would be, he's got a legitimate reason why he couldn't get the stuff done on time. If you make the respondent bring a motion for an order for an extension of time for service, he's gonna have to do that extra work rather than you consenting to it right now. If you make him bring that motion and he's got good reasons why he hasn't been able to file on time and you did not consent, he's gonna tell the judge that on the materials. And the judge is likely going to make the order that he's requesting, and
Mm.
you're going to get an order to pay costs because you should have not
Um,
made him bring that order. You should have consented to it. It was reasonable. You've taken an unreasonable position. You've made the other party do all this extra work. You are likely facing an order for costs.
oh my. Oh my,
So I
yes.
would say,
So costs
yeah, don't
still,
don't be unreasonable.
so costs still is still kind of like looming over your head, so to speak, in 14B motions that cost
It,
could be sort of
it
awarded.
could be. So if the person who's bringing the motion
Wow.
has got, okay, legislative authority for asking for what they're asking for,
Yeah.
if their need to ask for it is legitimate, and they've
Yep.
confirmed that and it's set out in their affidavit. If the other party is taking an unreasonable position and not consenting, which is why the order had to be brought in the first place,
Right.
then the unreasonable party could be made to pay an order for costs.
I understand now. Okay. And of course,
Sometimes, although it is very rare, it could be the other way around, is that it's the person who brings the motion says, I'm asking for this, and it's the respondent that says, no, that's unreasonable. You shouldn't have asked for it in the first place. Technically, the judge could have that moving party dinged with costs. But again, it's just if a party to a motion has been unreasonable in making the motion be brought in the first place, there's always the potential of cost consequences.
but do you have to include this in the draft order? The cost, like, I mean, cost is also part of the order, kind of, isn't it? So would you have to include
Yes,
this?
okay, so let's say applicant brings the application,
Yeah,
responding party needs an extension on time to file an answer.
right,
Applicant does not consent to the
right,
extension of time.
right,
Respondent brings a 14B motion for an
right.
extension of time to file an answer. This has to be done on notice.
Yeah,
And let's say the other side even objects to it, saying the person's a jerk. They've always been a jerk. They'll always be a jerk. I will never agree to anything that person wants.
yeah,
Then it goes before the judge, and the
yeah.
judge will say, reasonable grounds for why respondent did not get his answer filed in time. I am making an order for the extension of time for late filing, service and filing. And because the applicant was asked to consent, applicant took an unreasonable position, I'm
Mhm.
also making an order for costs against the applicant in the amount of
Okay,
$500, $1,000, whatever, for this motion. And it will be part of the judge's order.
okay. And but as
And then the judge's endorsement will be in the file, so even if the formal order isn't taken out, the
right,
respondent then gets materials done, serves them on the other side,
okay,
goes to upload them. The first response from the court is probably to reject, saying, you're out of time, and then goes, no, I've got an order in the court file that says I've got permission to late file. Oh, and guess what? She's also got a cost order against her. Then the clerk will look at the court file. If the formal order hasn't been taken out, they'll see the judge's endorsement and they're going, oh yeah, yep, you're good. And they will accept the materials to be
Oh,
filed. And meanwhile, the
interesting.
applicant's starting out with a cost order against them.
Interesting, very interesting. And one final question. Okay, I'm just gonna maybe even ask this, but I just want to double check. Because again, 14B is kind of mostly on procedural. So you can't, so if you want to ask for a temporary order for parenting time, let's say, right?
No,
But that's more of a substantive,
that's not a procedural, that's
that's
not a
not a
procedural
procedural. So
uncontested.
it,
That's a request for substantive relief.
right, so that's not a
Remember, that's
14B.
where we started saying, a request for substantive relief can only be brought in a legitimate situation of urgency or on an emergency basis. Other than that, if you're asking for substantive relief,
Right.
like custody, access,
Mhm.
child support, any of that stuff, you cannot do that until after your first case conference.
Until after you're okay. And then you could bring a
And even
regular,
then, it's not a procedural, uncomplicated,
no,
uncontested matter. That's
that's right.
not what 14B is meant to deal with.
So it's more like a regular motion that you bring.
Well, it is. Oh, okay, but let's say though, that right when a couple first separates,
Yeah,
there's an urgent motion brought and a temporary order is made that sets
right,
out terms of when the child is to
right,
be with each parent.
right,
So then the application actually gets going,
right,
because let's say the emergency motion was brought when there hasn't even been a court proceeding started yet. So the
right,
court makes an order and then says to the applicant, you need to bring your application. You got to do it now. So
right,
then the applicant makes their application, they
right.
do it, they serve and file it. The respondent does answer, serves and file it. And meanwhile, it's a couple of months since the emergency motion was argued and then the emergency order was made.
Yeah,
And now the parties have kind of settled down and they've agreed this is a little bit harsh and it's not really working out, that they really hadn't thought about what they were doing at the time. Now that they've settled into routine, they've actually come to an agreement on changing the order made on an urgent basis.
right.
They could do that by Form 14B.
Oh,
They could
interesting.
say this urgent emergency motion was made on this date without notice to the respondent. We've now been doing this for 4 months. We've been negotiating, we've reached a consent. We want to change, we're not agreeing on like for the final order in the whole case yet. We're still eventually going to go to trial, but for now, we have agreed to change the temporary order that was made on the urgent motion.
Oh, that's
And
interesting.
we signed it, we've each signed the consent that's attached that sets out what we want the temporary parenting time to schedule to be. And we have filed a draft order setting out what we want it to be in accordance with the consent. That you could do as a Form 14B
That is so
because
interesting.
it's on consent.
Right, right.
You don't see it happen that often, but technically
I
you could
see.
do that.
Okay, so like for child support, spousal support, or whatever, one of these substantive issues, if it's a there's consent, but it's a temporary order that you're
Yeah,
seeking,
it's
you
for a
could,
temporary order. Yeah.
right? Okay, that makes sense. Okay,
Support, they say you can do it, but I really,
you don't
that
like,
gets a little bit scary because in order, when you're dealing with support, there's so much other materials and documents that need to be filed.
uh,
Like, I get with child support,
yeah,
because the requirement is it's got to be in accordance with the child support guidelines, which is based on the payer's income. So you need to get all the documentation in your temporary motion to show that what everybody's agreeing to is actually in accordance with the legislation. So that's kind of usually the thing. I would let it wait until you're at a case conference or settlement conference because it's already in the application materials and stuff, and just get an
mm.
order on consent at your next court appearance.
So you could get orders from the conferences as well. Like
Yep, if they're on consent.
you've done, that's right, that's right, that's right. My goodness, like. Yeah, this is actually so many levels and layers in family proceeding. It's not as simple as as civil. Do you have any last words that you kind of want to say before I wrap up?
No, again, well, or
Maybe you
maybe,
do. Okay.
just maybe again, just always, always, always. Just because you're self-represented doesn't mean you get to skirt around the rules. You are
Right.
still required to follow the rules. You're expected to know them. Different courts do things differently in different jurisdictions. So as I said, read your notices of profession and practice directions for your region before you go to court.
Right.
And there are lots of really good online resources that will walk you through on how to do this type of stuff. There are the guides that are published by the Ministry of the Attorney General. And there's also Community Legal Education Ontario, their Steps to Justice Family Law website. Also
Mhm.
gives you a really good walkthrough on 14Bs and how to use them.
Right. Yes.
So
No, they are really
always
good.
make sure you do your homework before you just rush in and decide you're going to do something, to make sure that you're actually doing something you need to do or that you should be doing.
Sounds good. Okay, so on that note, I'm gonna say thank you so much for coming in today, just spending all this time educating us. And again, just a reminder for those who missed our live workshops that we held last fall with Shmuel Stern, another regular speaker on this channel. So these workshops are available now to view on demand. So I will have the link in the description box below. And these are ideal for people starting out a case or law students and lawyers who are wanting to learn a little bit more about family procedure. And thank you everyone for joining us today, and hope to see you the next time. Bye. All right.
Hi, thanks, Heather. It was fun as usual.
Thank you.